Somehow she shot herself and just died. No way, what happened? Oh, Star, I didn't see that. Can you hear me? So I can go ahead and read this shit real quick. Can you hear me? Lord have mercy. I wonder if you can hear me. Give me a thumbs up. I wonder, does this mean that I don't have to try to make sure I be on that call because tomorrow is Tuesday. I don't have any work to do Tuesday because I okay. So let me say this real quick because I swear I tried to leave the bullshit in April, so I'm hopefully I can leave the bullshit on May 9th. Okay, so I have no idea why in the hell y'all think that JoJo don't know that I have been talking to Fat Boy. He knows that. He could probably, he can, ain't no problem. He can show you the screenshots and shit, all kinds of shit. Like, do you think that I'm dumb enough? First of all, I'm not gonna trust somebody completely anyway. But definitely after I done been burnt. So try again. That's not going to work. Snitching. Okay, this is what I don't understand. Why are y'all so selective with the snitching? Why don't y'all call Fat Boy's girlfriend and his family stuff and snitch? Call the EBT people and the IRS. Why don't y'all do that snitching? Why don't y'all say, push the narratives that y'all try to push on him? Say this woman, she chasing Fat Boy. She done sent the roast beef coochie pig to him, and she this, that, and other. Why don't you call and tell her that? Snitch where it matters. Call and tell her that bullshit. Call her. Damn. Hell. Go ahead and set it up and shit before, the inevitable happen. Cause it's gonna happen, because I told you stop fucking with me. When I tell you you ain't gonna never be in Florida fucking with me, that ain't gonna never happen. Florida, Georgia, none of them motherfucking regions. No. Are you crazy? You too close. And think I'm gonna blow your ass up. Got me fucked up. The fuck is wrong with you? I'll send your ass to the moon with a thank you note attached to your ass. Crazy. Yeah, why don't y'all snitch where it matters? That's crazy as hell. The thing JoJo don't know. Huh? What the fuck? This shit is y'all must be don't know what the hell everything we was talking about. Cause once again, nobody can show nothing about I'm running after Fat Boy, I'm this, I'm that, whatever. None of that. Cause it's not true. I ain't set no motherfucking body up. I just passed the motherfucking message. You crazy? Damn. Y'all will do anything, baby. And see, here's the thing, right? Let me tell you something about my education. First of all, motherfucker, I didn't come out the womb with the fucking education. It took a way, a fucking path to get to where I am, right? Through that path, again, was the hood. I did 14 years in the motherfuckers. And it's in me, and it's gonna stay in me. An ignorant ass person, I guess, wouldn't know. A motherfucker that ain't never went to motherfuckers. What's good with it? Progress 2 times. That would know that obviously I don't go into nobody's motherfucking office or in no professional setting talking like this, like I'm talking to you motherfuckers. Because the motherfuckers that's on here aren't in the locations that I go into to work. The fuck is wrong with you? Who don't know that? Oh, stupid ass. Yeah, I know who don't know that. Motherfuckers that don't have nothing but a whatever grade education. That's the motherfuckers who don't know that. So my bad, you won't know it. Like, shut the fuck up. I said don't fuck with me. Cause I'm not the one with all of that. I'm not the one with that rah rah blah, blah all that bullshit. That's why I like arguing with girls. I like arguing with men and fighting men so we gonna get it over with. Shit. I was back and motherfucking forth. I don't have no tolerance for that shit. So let me read this here. So, listen, I don't know what all this gonna say, so I'm gonna have to go off the goddamn screen and shit. Yeah, I stalk every man in the streets. Prove it. Show it. That I'm stalking a motherfucker. Show it. How the fuck I stalk a motherfucker? How? How, Sway? But don't worry about it, because listen, when all them records come in, them call records and shit. See, here's the thing, right? I don't this YouTube shit, this is nothing. I tear your ass up at your house. That's what I do. Fuck this. When them motherfucking records come in, yeah, we're gonna see who do the stalking. Yeah, just keep on, keep on, keep on. I get a new statute of limitations, motherfucking goddamn date every time somebody says, "Well, I seen your picture. I seen your picture. Yes, it's gonna be epic." Y'all know I don't understand how this works. Y'all already know how I gets down. Damn. And I'm like, JoJo, she talking to Fat Boy on the side. Do you motherfuckers know what I'm saying to him and he's saying to me? Hell no. Apparently you don't, or you just like, you probably do. You just fucking liars. Oh, God, good riddance. But anyway, whew, child. In celebration of child, I almost played that motherfucking song. This is the song you play when you saying good written. I ain't gonna play that song. Woo! Let me read this paperwork before I start talking. Okay. So this is what J Bo is at it again. She's working hard. And look here, I ain't on the screen, care support. Listen, y'all gonna do not. I repeat, I don't give a damn if she lose every fucking motion. Please do not fuck with this lady and R. Kelly's relationship. Do not harass this lady and R. Kelly. Please. Because this lady is putting in work. And she pulling out her ass. But at least she's pulling it out her ass for her client and y'all boy. Leave this goddamn lady alone. Shit. And don't harass this lady about no stupid, petty ass YouTube bullshit. Leave this goddamn lady alone. This is good white people. And she don't deserve this. This is good white people. And when you have good white people, that's a good thing. Hell, I was like, woo, hell no, baby. Okay, let me read this. It says defendant Kelly's motion to adjourn the August 1st, 2022 trial date by 90 days. So she wants it by 90 days. That is good time for me to get down there and kick some of your motherfucking asses. Okay, let's see. It said, now comes Robert S. Kelly, defendant by and through his counsel, Jennifer Bonjean, and respectfully moves this court for an adjournment of defendant's trial date. Number one, the government filed a superseding indictment in this matter on February 13th, 2020. Number two, undersigned counsel filed her appearance in this case on February 18th, 2022. Number three, the government produced the discovery in this case on March 7th, 2022. March 7th? It's some more discovery? Oh, hell no. Y'all got to go and find some more. Y'all got to go find this discovery. Y'all, I need y'all looking there, McDavid. Look everywhere. Find this discovery March the 7th, 2022. Oh, hell. We got to find that shit. Okay. Number four, undersigned counsel was informed out of the gate that defendant McDavid had filed demand for a trial and that the court was eager to commence trial as scheduled on August 1st, 2022. Number five, in good faith, undersigned counsel has worked diligently to prepare for a trial on August 1st, 2022. But as trial approaches, it has become apparent that an August 1st, 2022 trial date is simply not possible if defendant is to receive effective assistance of counsel. Here she go with her tricks. Go on, J-Bo. J-Bo, Lord have mercy. J-Bo put that pressure on your ass. J-Bo said, it ain't gonna be effective if you don't let me, you don't push this shit back. Lord, Leonard Webber, you got something on your hands, baby. Girl, I got to like this lady. I'm telling you. Number 6. At the outset, the case is a complex one where the indictment charges 13 separate counts of conduct spanning 2 decades. Although there is some relationship between the counts involve 6 alleged minor victims. Okay, 6 alleged minor victims. Count 5 charges a multifaceted conspiracy that the government alleges involved numerous individuals and continued for over 20 years. Now, okay, so it's 6 victims. I kind of know it was a minor 1, 3, 4, 5, 6, right? I thought it was just 5. Okay, I'll go back and check it. All right, number 7. The discovery in this case is voluminous. The government initially produced 67 separate discs of material that undersigned counsel has been reviewing diligently, and which does not include 3,500 material, which is the Jinx Act. While some discs contain video and or audio, many of the discs contain tens of thousands of documents. Just by the way of example, disc 2 alone contains approximately 57,000 pages of documents, including financial records from various players and numerous financial institutions. Various players? Okay, I know what she probably mean by that. Number 8, last week, the government produced another 10 discs of discovery that undersigned counsel has yet to even been able to access, let alone read or a review. Undersigned counsel does not see a scenario where she could significantly digest the discovery in this case. Y'all look out. This might be the 100 devices. Oh shit. This might be the 100 devices. Oh god damn. Team Kels, wait a minute. Don't go yet. Wait a minute. Wait a minute. Shit. This might be the 100 devices. I don't know. Let's keep reading. Conduct an adequate investigation. Retain experts if necessary, and be prepared to commence trial by August 1st, 2022. Hold on, let me see if we can see what is it. Okay. All right. If undersigned counsel spent the next 2 months devoted entirely to defendant's case, something she cannot do, she still would not be prepared to try this case on August 1st, 2022. He might tell you that you need to look for outside help, or he might assign you some help, lady. He might remedy this problem for you, lady. Okay, number 9, to put a finer point on it, the indictment contains 4 counts of sexual exploitation of a child in which the government alleges that defendant coerced minor 1 into engaging in a sexually explicit conduct for the purpose of producing 4 separate sexually explicit video clips. There go to 4. It's 4 clips right there for minor 1. Undersigned counsel has reviewed the evidence in the offices of Homeland Security. One of the video clips is found on a tape that made its way to the office of the Cook County State Attorney's Office in the early aughts under unusual conditions. Jennifer, girl, I love you, baby. You be dropping dime on the case. You be dropping dime, girl. Yes, girl. What happened, Jennifer? Let's see. The second videotape, which contains clips identified as video 2 and 3, was only unearthed in 2019 when convicted felon and presumably disbarred attorney Michael Avenatti secured the videotape under nefarious circumstances and then produced it to Assistant State Attorneys Kim Fox. Number 10, according to the government, video 1 has been examined by forensic video experts, but video 2 has not. Whoa. Yeah, damn, she's telling all about the case. Tell it, Jennifer. Undersigned counsel would be derelict in her duties if she did not at least consult with the forensic video expert and have him or her review that work already conducted by the government's expert and possibly independently examine the videotapes that at the heart of the government's case. This is particularly true where the tapes allegedly depict conduct from the late 1990s and there is no chain of custody to speak of. So, over here we talked about the chain of custody so much that y'all should know what that means. So let me reread that. This is particularly true where the tapes allegedly depict conduct from the late 1990s and there's no chain of custody to speak of. So what you saying, the government hasn't done that, giving y'all that? Well, they don't have to right now. Okay, indeed, the tape that came through Abernathy has apparently been missing for nearly 25 years. An emphasis on missing. Additionally, defendant harbors serious concerns about whether his case should be severed from his co-defendants' cases. Okay, now who put in the severance from before? I thought that was the other guys. Defendant needs additional time to investigate and determine whether a motion for severance is justified. Okay, so he must be just thinking about doing it. All three defendants are charged with conspiracy to knowingly alter, destroy, mutilate, conceal, cover up, falsify, and make a false entry in any record, document, and tangible object with the intent to impede, obstruct, and influence the investigation and proper administration of any matter within the jurisdiction of the United States in violation of 18 U.S.C. 1519, count 5. Number 12, the government identifies a number of overt acts in furtherance of this conspiracy, including but not limited to: number 1, Kelly caused a Bass Productions Ltd check signed by McDavid to be issued to minor one's father in the sum of $30,000. Number 2, Kelly and McDavid caused a wire to be made from Bass Productions Ltd bank account to be paid to individual B to settle lawsuit that individual B had filed for payment for recovering and returning videotapes that depicted Kelly engaged in sexual conduct with minor one that had been stolen from him by individual D. Number 3, Kelly caused a wire transfer in the amount of $80,000 to be paid to McDavid through his firm, Winkler and McDavid Ltd, in September 2014. Number 4, Kelly caused a RSK Enterprise LLC check to be issued to minor one in the amount of $1,150. It's so little. Oh, shit. In October 2014. And number 5, Kelly caused a wire payment in the amount of $100,000 to be made from RSK Enterprises LLC to agent of McDavid on McDavid's behalf. Number 12, although defendant McDavid has not moved to sever, it seems likely his defense will be antagonistic to defendant's defense, at least in some respect, and vice versa. Right. So was it June Brown that tried to sever? Or did they just bring it up at a hearing? I mean, I don't know. Frankly, it is curious that McDavid has not moved for severance, but McDavid counsel has declined, as far as is their right, to shed any light on how they intend to try the case. So they haven't gotten with your ass. That's what you're trying to say. The defendant certainly intends to lodge a defense as to count 5 for the indictment that would be considered adverse to McDavid and may require introducing evidence that would be potentially prejudicial to McDavid. Oh, she telling her. Now, she might not be telling her strategy. This might be something she's thinking about. She's just putting it out there. Got to watch her ass. But she is good. She tricky, but I catches your ass, though. It says, financial records produced by the government reflect that McDavid had total control over defendants' finances for over 15 years. Whoa. Those financial records reflect highly unusual activity that may become a focal point of trial. Undersigned counsel must be afforded sufficient time to develop this viable defense, which may include hiring forensic accountants. 13. Lastly, the government has charged defendant with 5 additional counts of sexual abuse dating back to the late 1990s. Each count carries a statutory maximum of life imprisonment. God damn. God damn, girl, you be knocking me out when you be saying that. Let me gather myself. Wait a minute, let me take another drip of this orange. Just a great crush. Wait a minute, y'all. Mm. Shit, that's really the motherfucker. Dang. Undersigned counsel vehemently denies the allegations and must have ample opportunity to investigate these ancient aggravated sexual abuse claims that should have been prosecuted in the state court 2 decades ago. Now, you see, aggravated, right? So that word will play out during the trial as well as if he gets convicted on a PSR or PSI. And that where aggravated, that's where you get the extra points. All right. 14. Although undersigned counsel's other professional responsibilities are not a primary consideration here, they should carry some weight. Undersigned counsel is currently preparing for defendant sentencing hearing in the Eastern District of New York, where defendant faces a guideline sentencing range of life. Defendants request that sentencing in the EDNY case be adjourned until after the California trial was denied. Defendant request that sentencing in the New York case be adjourned until after the Illinois trial was denied. Okay, separately, undersigned counsel also starts trial on May 23rd in Los Angeles County, California, in the matter of Hughes versus Cosby, which was scheduled long before she filed her appearance in this case. That trial will not be a long one, but it prevents undersigned counsel from immediately prioritizing this case until next month. 15. Counsel had hoped that she would be ready for a trial on August 1st, 2022, but the case is far more complex than she anticipated. The discovery is extensive, and undersigned counsel cannot be forced to trial without having the opportunity to review the material in depth and approximately investigate the case. The counsel had hoped that she would be ready for it, but the case is far more complex than she anticipated. Discovery is extensive, and undersigned counsel cannot be forced to trial without having an opportunity. Hey, she be putting that motherfucker pressure on your ass. Woo, woo. 16. Additionally, the fact that the defendants currently incarcerated makes trial preparation even more challenging. Undersigned counsel must review the discovery with her client to make sense of it. Reviewing hundreds of thousands of pages of documents with an incarcerated person is incredibly difficult under the best of circumstances. Here, the task is even more difficult where defendant has significant literacy challenges and must rely on undersigned counsel to read documents aloud to him. The process is extraordinarily time-consuming. 17. For the foregoing reasons, defendant seeks a continuance of 90 days and suggests a trial date of November 1st. Signed, J-Bo. Anything else you got? Let me come around. Oh boy. Oh boy. What's good? Okay, let me holler at y'all real quick. What's up, Star? What's up? Hey, Progress 2 times. Hey, Lil Red. Hey, Queen Diva. Yes, y'all. Hey, Yalla is in the building. Yalla's in the building. Yes. Give me 1 minute, y'all. Let me do something real quick. Okay, I will. I ain't dropped the link in a minute. Let me go ahead. I can drop it for y'all. So, y'all know the link rules. I ain't got to repeat that over and over. So, wow. Listen, she go hard even in her her fucking simple request. Listen, she already is besetting this lady here. I'm gonna tell you, she played a long ball. She plays the long game. She already telling you, so to speak. If you force her to trial and she's not prepared, one, is going to be ineffective. Two, she will cite this as a constitutional violation of due process if it has to come up on appeal, under appeal, if she could file um, um, those violation stuff during the trial, she could do all of that. She's setting your ass up. And that's what a lawyer's supposed to do. Set your ass up. The hell wrong with you? You receive an honest and fair trial. Yeah, I believe he received an honest and fair trial. I believe that. You know, I believe that. I mean, now, do I believe his defense team could have done more or whatever? Yeah, that's always you're always, second guessing that. They second guess that. She second guessed what they did. So yeah, she said is that as much. Right. I definitely believe that. But that's crazy, right? She's not playing. She set your ass up under that law. She be like, look, I'm telling you right now, I'm about 110 pounds. I'm about 5'7". Okay. I'm a blonde white woman. Play with me if you want to. Play with me if you want to. She's not, man. She's not playing, y'all. She's not playing the radio. Not at all. That's her client. So you remember, because I did a live about severance, trying to explain what severance means. Does that mean that, because she said McDavid didn't formally file one, Kelly didn't formally file one, so was it June Brown? Did he file one? Or did he say, did he think about it? Well, let's see. We got a minute or so. I ain't gonna keep y'all long. Let's see something. First of all, she said it was 6 minors, right? So that is she saying there's 6 minors in the case? That's charged. I mean, that he's been charged for. Let's see. See if it means 6 charged acts. That's for his minors. Let's see. All this selective snitching shit. Snitch. Hold on. So let me pull up the indictment. Real quick and see. Let me count the minors. I do not remember. Okay. So we got minor 1, 3, 4, 5, 6. That's 5 minors, J-Bo. Where's the 6th one? You know something we don't know? Okay, you know what? I'm see, I don't like Illinois. Cause in here, hold on. This paperwork seem to be Because where is 91 and 92? Where is that? The documents. Well, like, they play too much. Okay, let me pull this up. Let me pull up. What the man name? Let me pull up June Brown. Ain't that the man name? June Brown. And see if he applied for the severance. Somebody applied for it. Greenberg said it. He said, well, he spoke about it. Well, maybe nobody applied for it and they were just throwing it around. And a man named June Brown. Okay, well, fuck that. Let's go. Now, where's all this discovery? Okay, she said she got it March the 7th. And I don't like this. I don't like this. I told you I don't like the Illinois. I told you that. Told you I don't like this. She talking about she got discovered on the 7th. Well, why nobody told us? Hey, like we supposed to know. Why nobody told us shit? Damn discovery. Who's in charge of the discovery? Okay, she said it happened. What she said, March the 7th? What I told y'all? March the 7th. Yeah, that's what it said. Okay. So March the 7th, because discovery. You ain't told us, nobody told us nothing. It tells us nothing. Not nothing. You got a discovery, you talking us a lot. You ain't told us nothing. Oh, let's see if we can find it in dirt. No, we ain't gonna be able to find. Wait a minute, we might be able to find something in his case. Hold on. Let's be nosy. We ain't minding our own business. We ain't minding our own business. Let's find his ass. See what he got. Find your bitch ass. Berell. Dance now with your big ass. Let's see if we can find on you. What the man name is? Hold on. McDavid. Daryl, that's what I put in there. Okay. Yeah, did somebody put it over here? Let's see if we. No, it's the same shit. Oh, wait a minute. Oh, there go the missing pages. Wait a minute. Oh, I found 91, y'all. Remember I said that's missing over there off Kelly's. Okay, wait a minute. Okay, 91 over there. What is okay? Let me see. What is this about? Okay. Oh, listen, y'all. Listen what David did. We all in their business, girl, because let me tell you what he did. So let me put this up here. No, I'll just read it. So on May the 6th, Darryl McDavid motion to adopt co-defendant R. Kelly's motion to dismiss. Let me read it. Okay, we're going to talk about it because they playing games. I'm telling you. Now comes the defendant, Darryl McDavid, buying through his undersigned attorneys and respectfully moves to adopt co-defendant Robert Kelly's motion to dismiss. In support of Mr. McDavid's adopts and reincorporates the both that wait a minute, who wrote this? In support, Mr. McDavid adopts and reincorporates the both the factual no, it reincorporates supposed to be both the factual and legal arguments put forth by co-defendant Robert Kelly in his motion to dismiss. Although Mr. McDavid is not charged in the counts Kelly is charged with, he is charged with him in counts 6, 7, and 8, and is respectfully asking for those counts to be dismissed. Respectfully, his attorney. Okay, hold on. Let me see now. J-Bo, did you just say, girl? Did you say you ain't talk to them people? Hold on. Okay, hold on. I ain't gonna say nothing. Let me see. Government discovered the 7 unsigned counsel response to the debit filed of the man. If a trial, it was eager to commence schedule in good faith. Unsigned counsel did the trial in August 1st. The process is becoming apparent in August 1st. Trial was sometime president defendant received his first counsel. Also, the second counsel. Okay, counsel. Okay, discovered this woman's. Yes, no. Okay, let's wait for this. Okay, scenario the judges the case for the court of okay, count sexual exploitation of examples. I'm going to engage in but sexual exploitation case. Unsigned counsel has reviewed it. Homeland Security is found. Okay. Okay. Okay, additionally, defendants considers concerns the case should be severed from scope in the case. Okay, additionally, defendant harbors serious concerns about whether his case should be severed from his co-defendant cases. Okay, well, the other attorney wants to adopt your motion to dismiss. Defendant needs additional time to investigate and determine whether the measure for severance is justified. Also, defendants are charged with a conspiracy known to alter, destroy, mutilate, conceal, cover up, falsify, and make a false entry in a record, document, entanglement, argument with the intent of impede, instruct, influence, and investigation of proper administration of any matter within the jurisdiction of the United States, a violation of 18 U.S.C. 1519. Okay, the government identifies number of overt and further conspiracy. Okay, hold on. Return of the deal takes the other McDavid has moved to sever. It seems likely his defense will be antagonistic to defendant's defense, at least in some respect, and vice versa. Frankly, it is curious that McDavid has not moved for severance, but McDavid's counsel has declined, as is his right, to shed any light on how they intend to try the case. Okay, I know, right. So how is they gonna adopt your motion? They can do that. But it's it's customary to get together with your ass to talk about it. And you're saying that like the council has not shed any light as to how they intend to try the case. This is what you said. Now you said this after the motion to dismiss. So that would lead me to think that you've had a conversation after they adopted your motion to dismiss. You've had a conversation about this, about maybe the strategy, how the strategy, or you say y'all didn't have a conversation. I'll go with what you said. Okay, defendant certainly intends to lodge a defense as a count 5 in an indictment that would be considered adverse to McDavid. So you gonna stab him in the back and make required introducing evidence that would be potentially prejudicial to McDavid. So yeah, you gonna stab him in the back. Oh, wait a minute. Hold on. The man try to adopt your motion to dismiss, but you come here days later and say, yeah, and we might stab his ass in the back. J-Bo, you a wild girl, baby. You wild as hell. Hold on, y'all. Let me put this up on the screen so y'all can see what I'm talking. Y'all, wait a minute. Oh, Lord. This shit gives me the giggles, honey. Oh, J-Bo said, and wait a minute, I'm going to stab your ass in the back. I'm going to stab your client ass in the back. Oh, shit. Oh, that's wild. What are you talking about? Oh, Lord have mercy. So this is the motion to adopt co-defendant Robert Kelly's motion to dismiss. That's what I'm reading. So you can find that under Daryl McDavid's. And for anybody needs a screenshot, I'll scroll through it real quick. Hell to the no. What? You gonna stab him in the back? Okay. Damn. Yes. Baby, she plays. Yes. Hey, Alvera. Yeah. He planned on everybody stabbing everybody in the back. Hey, Miss January. Yeah. Everybody's stabbing everybody in the back. What? Oh, hell no. Let me read some more. Let me read a little bit more of that air because I know I read. Let me reread it just to see. Okay. Everest requiring that potentially be prejudicial McDavid. Financial records produced by the government reflect that McDavid had total control. Ooh, you stabbing him in the back. Financial records produced by the government reflect that McDavid had total control over defendants' finances for 15 years. Those financial records reflect highly unusual activity that may be focal point of the trial. Undersigned counsel must be afforded sufficient time to develop this viable defense, which may include hiring forensic accountants. Now, I know I read that before, but when I went to look over there, be nosy, because we ain't mind our own business. I went over there to, be nosy, and I saw that, I saw 191. So, shit, what is that June Brown man name? I mean, is the other document over there on his on his file? Hell no, but we going looking. Don't play with us. Do not play. Damn, it's peaceful. Do not play. We knows as hell. We're gonna figure this out. What that man named June Brown? Did I not spell it right? Hell no. Is it Milton Brown? Some kind of Brown. Is it James Brown? Is it Bobby Brown? Oh, there you go. Milton Brown. It's Milton Brown. No wonder I ain't find it. It's Milton Brown. Milton, do you have that other paper? Let's see. See, stuff, you look at everything. Something sticks out to you. I said, where's the other? I said, just skipped around. So, Milton Brown, and that would be Illinois. There we go. Let me see how active Milton. Yep, Milton got 192, y'all. Yep, motion to adopt. Yep, then he got 192. Yeah, yep, that's where it is. Okay, let me see, dude. Let me see. Okay, now check this out right here. Now you mean to tell me, J-Bo, you expect me to believe your girl, because I fucks with you the long way, girl, that these other two attorneys, different attorneys on their cases, did not get with you, and on the same date, they decided to accept a motion to adopt your dismissal. Come on now, let me put this up here so y'all know I ain't fucking around. We gets to it over here, baby. I ain't lying. There it is right there. Now y'all saw McDavid's this June's child. This Milton. Girl, let me tell you what Milton attorney said. Let me tell you. Okay, defendant Milton Brown's motion to adopt, co-defendant Robert Kelly's motion to dismiss. Defendant Milton Brown by the Federal Defendant Program and its attorney. We got a public defender. No, that's okay. And its attorney, Mary H. Judge, respectfully submits this motion to adopt, co-defendant Robert Kelly's motion to dismiss. Listen, everybody's jumping on the J-Bo bandwagon. Like, bitch, you done did all that writing. We couldn't even say it like this right here. So listen, like, why didn't they, do another motion to dismiss or whatever? No, they saw how she done laid that shit out. They're like, yeah, this sounds good to me. This is what I'm talking about. As a lawyer, whatever profession you in, you ain't always got to work harder, got to work smarter. But you get on that phone and let a sister know what's really going on, right? But let me read. It says, it's in support. Mr. Brown adopts and reincorporates both the factual and legal arguments put forth by the co-defendant Robert Kelly in his motion to dismiss. On February 13, 2020, the government filed a superseding indictment charging Mr. Brown in count 6, docket 93. Mr. Brown respectfully requests that this court dismiss count 6 of the superseding indictment for the reasons provided in Robert Kelly's motion to dismiss. Yes. So we done found it. The missing shit. Yes, we found it. I'm back on the screen now. We found it. Yeah, Lord have mercy. What's good with it, shorty? What's good? Stabbing him. Hey, stabbing. They both say, listen here, I will stab you in the back. But my client, I know that's right. Oh my goodness. This is all right, y'all. Yelling Miss January, I added y'all back. Yes, honey. Yes. So listen, this is crazy. This is good though. But this is crazy. Girl, this is crazy, 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 honey. I'm reading this stuff. Yes, honey. This is crazy, crazy, crazy. Well, ain't that some shit? J-Bo says, listen, push come to shove. McDavid, you going down. 3 days later, after both the attorney, the co-defendant said, we're gonna jump on this motion to dismiss. She so eloquently laid out. Okay. I don't give a damn if she planning to stab us in the back. We trying to get the fuck up out of this case. Oh man. So you mean to tell me y'all ain't had no everybody decide on the 6th to jump on this motion to dismiss. But nobody ain't talked about the defense strategy. Are you hoping for a severance that that everybody can pursue their own defense, and have their own court hearing and all of that? Are you hoping that get done? But what if they don't give a severance? And you have to talk about the next logical thing is to plan your defense. Because when you have co-defendants, if you assign blame, that means that you're only just going to mitigate your guilt. That means you're not going to be completely innocent. But if you dump one point to one, point to the other, this, that, and the third, that could, exonerate one of y'all, two of y'all, or whatever. If whoever, depending on who y'all dumping it on. But if you say that anybody had any type of hand in this stuff or whatever, then you're kind of incriminating yourself, So you got to get together a little bit. Hey, Queen Diva, I don't know if I said Queen Diva. Yeah, you got to get together a little bit. So this here is crazy. It's a dirty game, baby. Oh, I gotta get lovely one back on him. What's good with it, lovely one, lovely one? Yes, honey. I thought I put my share yellow back in there. Okay, I got on there. Yeah, so this is crazy. This is cray, cray. I don't know what to say, honey. I am just like, huh? So we found the missing documents. And whoa, look, what did we find? Well, I know the ass. So I'm pretty sure everybody else will find them now too. I'm being petty as hell. uh-uh. You're on your own, baby. Oh wow. That's crazy. So yeah, hey, that's all I got. That's all I got. What they said, they threw that out most of the crime McDavid for what you read as an indictment. Yeah, he did he did the lion's share because I see Brown is just involved in one count, right? That's what they said. So when it comes to the conspiratorial part of it, this looks like McDavid did a good bit of it, right? But at the head of the conspiracy or at the adjoining part of the conspiracy, they are alleging R. Kelly is there. So, and that's just what it is. That's just what it is, folks. I don't know what. I don't know. Y'all don't have any questions or whatever, I can go and push off. But this is too much. Lord have mercy, this poor lady. Jesus. Miss Creamer, get your ass and go to bed, lady. Oh, hey, LaBelle. LaBelle. Man, I ain't gonna listen. I don't have time for that Illinois case. I'm just trying to tell y'all right now. The judge don't do the stuff like I want him to do. The people don't put the shit in the system like I like. Hey, I just might as well go in there and see. Listen, let me tell you something. I'm not going in there to try my goddamn ID fucking around no R. Kelly case, baby. I ain't gonna Tasha K me, have me up there talking it being the newspaper and stuff, and then have Sylvia and them over there reading about what I done. I don't even try my ID on no shit like that. Nope. I don't want to see if it worked. I don't want to know. Ooh, I don't want to know. I put some shit in there, but I ain't fooling around. Nope. I have to load stuff in there and I leave it in there. It's been up for years and years and years because that's what my students use or whatever to teach them all type of stuff, right? But listen, I'm not fooling around, child. I'm so damn nosy. And what y'all hear about? Oh, wait a minute. I know what I was supposed to be looking for. I was supposed to be looking for that damn discovery to see if I'm so goddamn I forgot what I was looking for to see if anybody turned in some discovery. If anybody want to tell us about discovery that came through on what they say the 7th, March the 7th. That was J Bo said she got it. Ain't nobody told us shit. So that's Kelly. Like, when's somebody gonna tell us something? We wanna know. Okay. Hold on. Wait a minute. Who is this? Hold on. Okay. All right. Yep. Nope. I can't find nothing. I cannot find nothing. Where is the discovery? So hey. So don't they have the? Hold on. Let me know. Hold on. Let me look out. Hey, I tell you, I don't remember this. I don't remember this shit. Long all that fucking long time we don't went over this damn case. Hold on for a minute. Didn't they do the discovery over here already? Hold on. Jabo said I'm gonna stab him in the back. Get your ass out of here. Okay, that's the motion for discovery. Noted. Okay, wait a minute. Let me see what this is. Okay. That's him, his little funky ass orders. Let me stop talking about Lynn Weber because I had to go through and look because this crazy. We're gonna find it. But anyway, y'all, honey, that is all I have. Child. Brown said he's in dying for just being there. Right. Right, Queen D. We like, I ain't did nothing. How I get in this? Why I'm in jail? Like, what the fuck? I gotta be in jail for all this? Yeah, so honey, the saga continues. This is man, this right here. This ain't anyway, y'all. That's all I have. Thank y'all for coming on through. I'll see y'all on the next live. Hopefully it'll be tomorrow. Because that's gonna be after the status hearing at 9:45. I think I know I put the information on the wall how to call the number and the code and stuff and the time and stuff. So but anyway, that's what I should be doing. So I will talk to y'all on tomorrow. Peace out. Thank y'all for coming on through. Bye.